I'd just like to say thank you so much to Property Rights Australia for inviting me to come here today and speak. I think your message of stand your ground is the work that Property Rights Australia has done is doing now and has done in the past. You've been an organisation that has been a key number of volunteers that has benefited many, and it's just inspiring to people like me to be able to keep going with problems like I'm facing. So firstly, you'll find that a key theme of what I'm talking about today is governance, oversight, accountability and transparency. Could be known as GOAT, and GOAT absolutely, where government and gas mining is concerned, does not stand for greatest of all time. I'm starting by saying that I'm a farmer, not a lawyer, so what I'll share today is based on my experience and views, not legal advice. If you're dealing with similar issues, I strongly encourage you to seek legal advice tailored to your situation. In 2022, Geoscience Australia published a report showing that between 2014 and 2021, our farm sank unevenly. I've put a circle there of our farm's location. Some of areas of it have sunk a lot, and you can see up to 30 millimetres per year downwards in that period, and other parts of it haven't sunk at all. Our farms in the Dalby floodplains benefit from fertile soil, a favourable climate, reliable irrigation and proximity to transport hubs. These ideal conditions support intensive cropping, optimising land use, rotation and input management for sustainable high-yield production with minimal water use and environmental impact. Most farms in my area are held under freehold land tenure. The area is an important agricultural resource identified as vital to Queensland through statutory planning instruments. As said by the State Planning Policy for Agriculture, Queensland's agricultural resources are of state and national importance and should be protected from incompatible uses and irreversible impacts that would compromise existing or potential productivity. With sound management, these resources can support agricultural production in perpetuity. However, these resources are finite and cannot easily be restored once removed, disturbed or degraded. This policy to protect and preserve agricultural land is more rigorous than the state planning policy for mining and extractive resources, which only aims to safeguard extractive resources from potentially incompatible future land uses. The Regional Planning Interests Act 2014 manages the impact of resource activities and supports their coexistence in areas of regional interest, including key agricultural regions like our farm. Under this Act, much of our area is zoned as strategic cropping area and a priority agricultural area used for priority agricultural land use. Less than 3% of Queensland is zoned as priority agricultural area, a small but critical portion of land identified as essential for our economy and future generations. Priority agricultural areas are protected by legislation to ensure their continued viability for agricultural production for future and current generations. Parts of the Shell and PetroChina subsidiary Arrow Energy's Dalby expansion and Surat Gas coal seam gas mining projects lie within priority agricultural and strategic cropping zones. Our farm near Arrow's Dalby expansion project and within Arrow's Surat Gas project area is directly impacted by this mining. Arrow began mining gas west of our farm in 2017. By 2014, gas wells had reached our western boundary. And by 2020, our farm was fully surrounded. The mining uses vertical and directional wells to extract methane gas from underground coal seams, a method classified as unconventional gas mining alongside shale and tight gas extraction. After lodging a complaint with the Queensland Government in 2021, I discovered that Arrow Energy was legally required to notify us of its directional wells if its directional wells were to enter our land, yet we had not received any such notification. Arrow's plan of operations submitted to the State Environment Department said that the wells on our boundary were to be vertical and therefore confined to neighbouring land. After they had been dug, Arrow confidentially logged them with the State Resources Department as directional wells entering my farm from neighbouring land. Following this revelation, Arrow Energy was forced to publicly disclose that prior to 2021, it had secretly dug 48 directional wells into the properties of 13 landholders from surface pads on neighbouring land. This included 5 wells dug into our farm in 2018 and 2019, one of which goes across the square irrigation dam you'll see in the slide underneath. I was astounded that despite modern data matching capabilities, government had no system in place to ensure information reported to its Environment Department by CSG miners was accurately cross-checked with records logged by its Resources Department and the Office of Groundwater Impact Assessment. There was no mechanism to monitor whether private landowners were being properly notified about gas wells on their land. An additional 12 directional and vertical gas wells progressively put into mining production between 2015 and 2020 are within metres of my boundary. These neighbouring wells, along with the others in my area, have caused subsidence issues on our farm, disrupting drainage patterns, reducing crop yields, preventing us from growing crop in some years, and causing water to accumulate in sunken areas. Arrow Energy has acknowledged that our farm is subsiding due to their mining activities, yet they continue to deny that the subsidence is causing any impact on our land to us. For failing to comply with private land access notice requirements, the Department of Resources fined Arrow Energy $1 million, equating to just $28,333 per unlawful directional well. The department ignored potential impacts on the land, farming businesses and individuals. Instead of requiring Arrow to make amends and compensate landholders like me, the government kept the entire fine with none allocated to farm restitution or subsidence research. This inaction highlights a systemic failure. The regulating penalising Arrow Energy, requiring it to pay the government, which was already receiving royalties. Despite being fined, Arrow simply continued its mining operations and royalty payments to government, while landowners received nothing and were left to bear the full financial and operational burden. Incredibly, in a society that claims to uphold democracy and social licence for the unconventional gas industry, landowners like me must fight for basic protections whilst a multinational coal seam gas miner, having trespassed on private land, operates with impunity. This situation illustrates the wider failures in regulation, oversight, accountability and transparency within Queensland and Australia's governance of the unconventional gas mining industry. In early 2020, we noticed sunken areas had begun to form in our western paddock, disrupting surface water drainage and farming operations. Given the farm's stable soil type, the area's geological stability and the absence of groundwater irrigation, melting permafrost or decaying peat bogs, coal seam gas mining remains the only possible cause. In this paddock, which you'll see on the screen, the interval from rain to seeding is 10 days. In 2022, Seeding was not possible due to stagnant water accumulating in newly formed sunken areas. These depressions formed after Arrow Energy began mining coal seam gas from the reservoir beneath our farm using vertical wells on neighbouring land.
I guess you've had expenses in actually laser levelling a lot of this land to get it in the profile you require as well.
Well, mining methane gas from coal seams involves extracting salty, contaminated water, reducing pressure and allowing gas to escape. This causes the coal to shrink and compact, leading to surface subsidence. The lenticular coal seams in my area are irregular, discontinuous, and vary in thickness and connectivity. These lens-shaped coal deposits tend to be short, fragmented, and contain methane at inconsistent concentrations, creating unpredictable extraction patterns that increase localised subsidence risks. Coal deposits often taper off entirely, preventing uniform gas removal and intensifying uneven ground movement. In the Surat Basin, significant groundwater extraction by gas miners accelerates this process. The coal in this region is notably wet compared to other areas, which affects gas desorption and extraction dynamics. Thin, short, uneven seams at varying depths make subsidence difficult to predict and model, leading to differential ground movement that continues to develop on our farm. Subsidence also fractures underground strata permanently, triggering microseismic events and threatening irrigation dams, drainage systems, and aquifers. Recent preliminary modelling by the Office of Groundwater Impact Assessment, known as the OGIA, obtained through Right to Information, indicates that both the occurrence and extent of subsidence are highly unpredictable, much like a lottery, where outcomes vary significantly and lack certainty. My area is a heavily cultivated floodplain with low slope, where even minor landform changes can disrupt cropping, water flow patterns, access to surface and overland irrigation, drainage, soil health, and land productivity. This makes it highly vulnerable to subsidence impacts. The OGIA, in its 2021 Underground Water Impact Report for the Surat Cumulative Management Area, known as the 2021 UA, found that a single CSG production well causes depressurisation for up to 10 kilometres away from the well. In my experience, I have found the state and Commonwealth government departments responsible for administering environmental protection, petroleum and gas, land access, water, and planning laws struggle with a fragmented and inconsistent approach in relation to the unconventional gas mining industry. I found each department mostly operates in its own silo, often failing to understand the full scope and intent of the laws that they enforce. There is little meaningful coordination between them, leading to contradictory interpretations, bureaucratic inefficiencies, and regulatory gaps that leave impacted landowners like me without effective recourse. In its former role as the Gasfields Commission Queensland, Coexistence Queensland was meant to facilitate dialogue between landholders, government, and the resource sector. However, my experience has been, rather than ensuring strong protections for agricultural land, its function seemed to be promoting unconventional gas industry-led coexistence narratives that failed to reflect the real experiences of adversely affected landowners. Instead of providing meaningful solutions, the disjointed administration of the myriad of laws regulating CSG mining and its waste has resulted in either poor outcomes or worse, complete non-outcomes for those already impacted by subsidence. I found that while I seek clarity and assistance, I am caught in a cycle of miscommunication, with departments passing responsibility rather than working together to enforce current laws and deliver cohesive, enforceable protections for emerging problems. This systemic failure undermines the confidence in regulatory oversight and allows miners to proceed largely unchecked at the expense of those like me who rely on the land for their livelihoods. Beyond my own farm, this raises serious questions about landholder rights, agricultural sustainability, and the integrity of land use decisions. My experience is a stark reminder that without proper unconventional gas mining industry regulation, oversight, enforcement, accountability, and transparency, farming families will continue to bear the real costs of CSG mining from their own personal income, assets, and superannuation, costs that are seemingly ignored by policymakers and the mining industry. It has now been exposed that more than a decade ago, both the government and the mining industry acknowledged that CSG extraction can lead to subsidence. Since then, little effort has been made to research, measure, or monitor its impact, particularly on cropping land. No long-term data has been collected at a scale relevant to intensive cropping. Farmers are now facing a major issue. There is no established scientific framework to demonstrate subsidence at a resolution accurate enough to confirm impact at a cropped paddock scale, nor a clear legislative process for seeking compensation. With Arrow Energy overseeing data collection and owning the data collected, there has been no incentive to gather evidence that could confirm its responsibility to affected landowners. This lack of scientific oversight has enabled the government to allow the mining industry to continue mining unhindered, putting important cropping land at risk, altering overland water flow on my farm and risking permanent change to flood patterns. Like many other farmers, we didn't collect our own measurement data over the years, having been assured that the subsidence wouldn't pose a problem to our land or operations. One of my biggest concerns is subsidence monitoring. INSAR, Infometric Synthetic Aperture Radar from satellite, can detect ground movement, but is unsuitable in cultivated areas like my farm. Crops and dense vegetation scatter radar signals, causing inconsistent measurement as plants grow, move, or are harvested. Frequent soil disturbances from ploughing, irrigation, and planting further mask actual subsidence. Since INSAR relies on comparing satellite images over time, the rapid landscape changes in cropped areas lead to data loss, making it ineffective for tracking subsidence. Arrow Energy has used aerial laser surveys, known as LiDAR, to assess ground movement. Arrow Energy's regional LiDAR, though, is unsuitable for paddock-scale subsidence monitoring. It captures surface elevation but cannot differentiate between standing water, crops, and actual ground movement, leading to underreporting. Aerial scanning lacks ground truthing, so it ignores soil conditions, crop growth, and visible farmer-observed changes. Its resolution is too low to detect subtle terrain variations, allowing Arrow Energy to dismiss significant landholder reported impacts. Accuracy is based on a 67% certainty level for unobstructed surfaces, but vegetation and terrain variations reduce precision on cropping land. Arrow Energy controls data collection with no independent verification, allowing its downplay of land damage. In my experience, its reliance on LiDAR conceals subsidence impacts. Right to Information revealed that the Office of Groundwater Impact Assessment, OGIA, endorsed Arrow Energy's LiDAR data without proper scientific investigation, prioritising minimising the cost to Arrow of monitoring subsidence. The data is too broad to accurately reflect cropping land impacts, and neither the OGIA nor the government can assure its usefulness for landowners seeking compensation. On our farm, the first to publicly report subsidence impacts, the available data lacks the accuracy needed to reliably identify how subsidence affects cropping operations. Right to Information requests revealed that in 2022, the OGIA had wrongly labelled me and other landowners whose farms are subsiding as ideologically opposed, raising serious, legitimate questions about bias and scientific repression. Instead of recognising landholders as legitimate stakeholders, our concerns were dramatised, dismissed or diminished based on preconceived narratives that favoured gas mining industry interests over objective governance. Public servants are expected to act fairly, transparently and impartially, yet retaliatory comments work to discredit farmers experiencing actual subsidence from gas mining. The OGIA 2021 EUA subsidence model, exposed through right to information, relied on broad averages, making it incapable of predicting the real subsidence affecting farms. Right to information also revealed that within government, in 2023, the executive director of the OGIA, Mr. Sanjeev Pandey, accused landowners, including me, of weaponising the OGIA subsidence model to create angst. Simply, it seemed, because at a meeting, none of us landowners produced a scientific measurement which proved subsidence had occurred to and already impacted our farms. I was also accused of making personal accusations against him simply because I and other landowners raised valid concerns about the limitations of the OGIA model, particularly its inability to accurately predict subsidence at the paddock scale. As I had exposed this through right to information, I was shouted down by Mr. Pandey when pointing out issues with INSAR pixel size. I thought he seemed reluctant to acknowledge shortcomings in his modelling approach. My concerns were dismissed rather than addressed, and the session was concluded abruptly after I used the pre-released version of the OGIA LiDAR elevation profile tool, which uses Arrow Energy's data, to show that on a broad scale, subsidence had actually occurred to my paddock in the area where photos and video I had shared on social media showed ponded water trapped in subsidence depressions. Yep. So you can see on the left, there's A, B, just keep clicking through it. So we have more subsidence in the areas where you just saw in the photo where the water was ponding. And you can see this over here on this chart, where there's more subsidence here where towards A, and over here where B is, that you can't see, there's pretty much nothing's been happening. So we've had ponded water here and along this boundary, because there was gas development in the western area a long time before any gas development on the eastern side of the creek, and the creek area hasn't sunk and the part to the west of it has. And because it's a very low slope, the water just then gets stuck in the paddock. It's just a horrendous situation. This example reflects what I believe to be a broader culture of hostility within the OGIA towards landowners whose farms are subsiding and being impacted by subsidence caused by CSG mining. Despite being an independent entity, the OGIA lacks proper governance, oversight and accountability and transparency, operating under a shroud of secrecy and under a single individual's control. The Resources Department demonstrated lack of enforcement by failing to uphold the legal requirement for a conduct and compensation agreement known as a CCA between landholders and gas companies where mining activities have more than a minor impact on the land and the landholder's business. Instead of ensuring miners comply with the law, the department tells landholders to take the matter to court, a process that is time-consuming, costly, and inaccessible to most. This deliberate abdication of responsibility means that landholders are left to fend for themselves in legal battles against large, well-resourced corporations. Rather than acting as a fair regulator, the department has effectively created an environment where miners can operate seemingly as their own regulator and without meaningful accountability. Coal seam gas mining-induced subsidence potentially falls under many Queensland and Commonwealth laws. Yet despite their existence, in my experience, regulatory enforcement remains weak or non-existent, leaving intensive cropping without effective protection. The Commonwealth Environment Protection and Biodiversity Conservation Act 1999, known as the EPBC Act, is meant to provide environmental protections for matters of national environmental significance. In simple terms, for CSG mining, this is flora, fauna and water resources. Arrow Energy's mining activities in my area are the Dalby Expansion Project, a non-controlled action if undertaken in a particular manner, and the Surat Gas Project, which is an environmental approval with conditions. In practice, I discovered that conditions for these projects do nothing to protect agriculture, nor do they require the keeping of information necessary to establish whether Arrow's gas mining has impacted the agricultural use of land and surface water in cultivated areas or at a cropping farm scale. Information I found through Commonwealth Freedom of Information processes and online supports a conclusion that Arrow Energy began its Surat Gas project before satisfying mandatory regulatory requirements, failing to notify authorities as required, and proceeding without mandated subsidence monitoring and environmental protection measures in place. Instead of holding Arrow accountable for these failures, when I shared them with the Commonwealth Department of Environment and publicly on social media, the former Commonwealth Environment Minister, Tanya Plibersek, early in 2025, allowed the retroactive alteration of the Surat Gas project conditions, effectively legalising Arrow's unlawful activities after the fact. The Queensland Environmental Protection Act 1999, known as the EP Act, regulates environmental impacts from mining, but impact to agricultural use of land from subsidence caused by CSG mining impact to agricultural use of land from subsidence caused by CSG mining is not explicitly recognised as environmental harm under its provisions. I was told by the former Department of Environment and Science that the department as regulator holds the position that environmental harm under the EP Act does not apply to the agricultural use of land. This provides no assistance in addressing mining-related subsidence impacts on farming operations. The Queensland Water Act 2000 governs underground water, surface water and overland water management, which is critical since CSG mining removes water from the coal seams, leading to subsidence and altered water movement. Despite my area's location within the Murray-Darling Basin, where licensed irrigation surface water could be reduced if environmental flows decline from the subsidence caused by CSG mining, the OGIA in its 2021 EUA did not comprehensively model water flow changes, a significant omission given the potential for disruption to surface and overland water from subsidence. To my knowledge, there is no monitoring by the Department of Water under the Water Act of changes to surface and overland water flows caused by CSG mining-induced subsidence. This suggests that the government is either failing to recognise subsidence as a surface water impact requiring intervention, or is deliberately obscuring the issue in the hope of reducing risk of Queensland's irrigation water entitlement under the Murray-Darling Basin Plan being reduced due to gas mining subsidence. Although the OGIA is responsible for evaluating cumulative groundwater impacts from CSG mining, its role in subsidence monitoring remains limited to modelling regional subsidence and a small-scale project focused on 2 farms, where subsidence is being modelled at a finer scale. Notably, the small-scale project has been underway for 2 years, but has still not passed the technical review process, raising concerns about the scientific rigour and procedural approach of the OGIA. CSG miners benefit from a statutory right to take associated water along with methane gas, allowing them to extract groundwater without needing a separate water licence. Long-term cumulative impacts are ignored, as there is no direct requirement for these matters to offset or remediate groundwater depletion caused by their activities. While make good groundwater obligations require CSG miners to compensate bore owners if their water bores are impaired due to mining activities, these provisions are reactive, not preventative, and do not relate to subsidence. There is no cumulative management area designated for subsidence, leaving landowners to try to seek compensation from multiple resource authority holders who cumulatively are causing the land to subside. There appears to be no statutory right to compensation for cumulative subsidence caused by miners outside of the specific tenure where the landholder is experiencing subsidence impacts. Landowners are legally forced to allow CSG mining and endure its impacts, whether or not mining infrastructure is present on their land. Yet due to state government policies, landowners may have no statutory right to compensation for cumulative impacts from CSG mining done in neighbouring and nearby tenures. Ultimately, the subsidence model of the OGIA is only a model. It relies on assumptions, historical data, broad averages, and predictive algorithms to estimate terrain and water flow changes. While modelling, if done on a fit-for-purpose scale, may be a valuable tool in understanding potential impacts, it can never replace actual monitoring and measurement. Without continuous on-the-ground monitoring, uncertainties will remain about the full extent of groundwater and surface water disruptions from CSG mining activities. The Queensland Planning Act 2016, statutory planning instruments being state planning policy and regional plans, guide land use decisions by seeking to balance CSG mining development and agricultural sustainability. I've found that the Planning Department, as a public service, has failed to enforce the Regional Planning Interests Act 2014, known as the RPI Act, to support these state planning instruments, effectively allowing a multinational miner to circumvent law enacted democratically. This has enabled the subversion of the state interest in agriculture and the Darling Downs Regional Plan, prioritising resource sector interests over the protection of farming operations. This failure reflects a broader issue where public servants tasked with upholding legislative integrity are instead facilitating the erosion of legal protections through non-enforcement. Even though Arrow Energy has claimed that the 5 CSG production wells it dug secretly into my farm are exempt under Section 24 of the RPI Act, they are instead unlawful as they do not meet the required criteria because the Strategic Cropping Land Act 2011, known as the SCL Act, was in force before the RPI Act commenced. Arrow amended its environmental authority after the SCL Act commenced, which triggered the requirement to comply with the SCL Act. The number of production wells Arrow's environmental authority authorised before the commencement of the SCL Act in Petroleum Lease 230, where my farm is located, were all dug and in production prior to the commencement of the RPI Act in 2014. The 5 production wells dug into my farm are in a strategic cropping land map area under the SCL Act and a strategic cropping area and priority agricultural area under the RPI Act. Arrow did not obtain a strategic cropping land protection decision or a strategic cropping land compliance certificate, either of which were necessary to be able to dig more wells in PL 230 in a SCL area had those wells been dug prior to the commencement of the RPI Act. Because the wells were not authorised by a compliance certificate or protection decision, the SCL Act prevented the EP Act from giving environmental authority for the wells. Without these approvals, Arrow could not have lawfully dug or operated the 5 wells on my farm before the RPI Act commenced, in the absence of my agreement or a regional interest development approval, a rider granted by government under the RPI Act. The 5 wells secretly dug into my farm by Arrow Energy are an example of public servants in the Department of State Development, Infrastructure and Planning failing to act against corporate self-regulation, even where clear unlawful actions exist. Despite over 2 years of investigation, the department has been unable to justify Arrow's legality. In doing this, the regulator has effectively enabled a multinational entity ultimately owned by foreign shareholders and the Chinese government to become the regulator, undermining statutory safeguards, creating an unlawful agenda in practice, all despite the legal framework being in place. Queensland's planning framework has failed to effectively protect, legislatively safeguard agricultural land from the long-term impacts of CSG mining. This has sent a troubling message to the international mining industry that compliance with law is optional rather than strictly enforced, leaving areas supposedly protected from long-term mining damage open for business. To the agricultural industry and its financiers, the message is clear. Their investments are no longer secure and they may need to consider asset divestment. This failure in enforcement also means farmers like me must fight for recognition, recourse and compensation rather than having a system that proactively defends rural land use. The Queensland Petroleum and Gas Production and Safety Act 2004, known as the P&G Act, regulates such things as mining activity, landholder rights, miner rights and safety requirements for petroleum and gas mining. Section 804 provides that mining activities must not unreasonably interfere with existing land use. I thought this provision was meant to protect landowners like me from disruptions caused by gas mining. However, I've found the departmental enforcement has been non-existent, allowing CSG miners to proceed with activities that directly impact farming operations unchecked. The Mineral and Energy Resources Common Provisions Act 2016, known as the MERC-P Act, sets out general access laws for CSG miners, including requirements for notification, access and compensation. Despite requiring compensation agreements for resource activities having more than a minor impact on the land or landholder's business, Arrow Energy has been allowed to self-regulate and in my experience refuses to enter into these agreements for landholders with directional wells but no surface infrastructure, leaving affected landholders without negotiated compensation. Instead of requiring compensation for directional wells, Right to Information disclosed that one of the focuses of the Resources Department was ensuring that landholders could not claim compensation up front. The LNP state government under Deputy Premier Jared Blay must urgently and fairly address the unresolved failures within the Regional Planning Interests Division of his planning department. These failures originating under Stephen Miles of the previous Labor government have left landowners unprotected against subsidence impacts caused by Arrow Energy's CSG mining activities. The Petroleum and Gas Production and Safety Act, known as the P&G Act, simply speaking, defines CSG and its associated water extraction as occurring from the reservoir in which it is contained, rather than from the individual land parcels where CSG wells are located. The government has said that under Section 81 of the Mineral and Energy Resources Common Provisions Act, was that the last slide? Could you go back one, please? The government has said that under Section 81 of the Mineral and Energy Resources Common Provisions Act, known as the MERC-P Act, landowners are entitled to compensation for subsidence caused by resource activities. For CSG mining, these resource activities are defined by the P&G Act. Under the P&G Act, the resource activity refers to the extraction of CSG and its associated water from the underground reservoir where it is contained to produce the gas rather than the presence of CSG wells on the land itself. For the purposes of the RPI Act, resource activities are also defined by the same provisions in the P&G Act. The Queensland Government must acknowledge that the PNG Act's definition of resource activity applies consistently across the MERC-P Act and the RPI Act. Government failure to enforce this under the RPI Act, despite that Act sourcing the definition from the same provisions of the PNG Act as the MERC-P Act, has led to a serious denial of natural justice for subsidence affected and at-risk landowners like me in areas of regional interest. Arrow Energy has proceeded with the development of approximately 180 CSG production wells in my area without obtaining regional interest development approval known as RIDA, or securing agreements with all landholders affected by or predicted to be affected by subsidence caused by its production of CSG. The company has argued that its operations fall under Section 22 of the RPI Act, which provides an exemption when an agreement is reached with landholders and conditions relating to impacts are met. However, since Arrow has failed to establish the necessary agreements with all landhold owners for all CSGLs within the impact radius of each CSG well, I understand that Arrow's claim of exemption under Section 22 is invalid, meaning the wells are all unlawful. The Oggia 2021 EUA confirms a single CSG well can cause depressurisation of up to 10 kilometres away, and that depressurisation causes subsidence. The Gasfields Commission Queensland's regulatory review of CSG-induced subsidence discussion paper and final report confirms landowners need not have mining infrastructure on their land to claim compensation. Statements by the Department of Resources and Treasury reinforce that the right to compensation for subsidence caused by CSG extraction does not require mining infrastructure to be on the land. Arrow Energy's commitments to the Surat Basin landholders acknowledged compensation rights without CSG mining infrastructure being on the land. Since Arrow Energy has apparently not met the agreement requirements outlined in subsection 2 of Section 22 of the RPI Act, further conditions relating to impacts to other owners of land or likely impacts to the region are not able to be considered because all conditions for exemption are automatically invalid where there is no agreement. This would mean that the 180 or so CSG production wells, including the 5 secretly dug into my privately owned land, require regional interest development approval or need to be plugged and abandoned. Arrow must be prevented by the Chief Executive of the RPI Act from digging any more wells until it has obtained RIDA to produce CSG from the impact area of the wells or secured the agreement of every relevant landowner, and subsidence impacts where subsidence has already occurred must be fairly addressed, mitigated and compensated for. The government has an obligation to correct these seriously regulatory failings because it is responsible for enforcing the RPI Act and ensuring compliance with its provisions. If Arrow Energy has not met the agreement requirements under subsection 2 of Section 22, then the exemption is invalid, meaning regulatory enforcement should apply. The government has a duty to protect landholders' rights and human rights, uphold agricultural safeguards and ensure fair compensation for impacts like CSG mining-induced subsidence. Yet it is clear to me that there has been a disgraceful failure by government, leaving landholders vulnerable to unmitigated subsidence damage. My experience with Commonwealth and state government, including the Oggia and Coexistence Queensland, has reinforced my belief that policy change is urgently needed. Without meaningful communication and consultation, proper governance, true accountability, genuine oversight, real transparency, and suitably regulatory enforcement, more farming families will continue to bear the real cost of unconventional gas mining resource development, costs repeatedly overlooked by policy developers and decision makers who lack both the qualifications and understanding of agricultural land use realities. Government inaction has forced landowners to fight for compensation while bearing the financial burden of mining impacts. Without comprehensive reform, property rights remain at risk.